Will democracy survive the next couple of years?
Access to Democracy is made possible by donations from the following organizations. Thomson Reuters, a global company with expertise and insight to unravel complex situations in the areas of law, tax, compliance, government, and media. Their worldwide network of journalists and editors keep customers up to speed on relevant global events. Thomson Reuters, The Answer Company. Crutchfield Dermatology, a full-service treatment center and Medi-Spa in Eagan. Their goal is to help you look good and feel great with beautiful skin. With service built around courtesy, dignity, and respect, Mayo-trained Dr. Charles Crutchfield personally treats each patient and is acknowledged as one of the nation's best physicians. Truestone Financial, with locations in Minnesota and Wisconsin, has proudly served its members since 1939. Truestone engages, educates, and supports its members to ensure they have the tools to empower their financial well-being. Truestone Financial, your neighborhood credit union. Learn more at truestone.org. Edina Eye Physicians and Surgeons, a division of Twin Cities Eye Consultants, has proudly served the Twin Cities for more than 55 years now, in 7 convenient locations. Using the most advanced technology combined with human touch, Edina Eye offers comprehensive services and dedicated specialists committed to excellence, with innovative procedures and expertise for the most advanced eye care.
Welcome. Access to Democracy returns, and what a pleasure to be back after almost 20 months. I have to say, and this is Alan Miller, I guess I am the patron saint of Access to Democracy, whatever that means, that without the help of not only Mary Dalkey at the controls, but the people of Eagan TV, this would have even been more difficult. It's such a pleasure to be back in the studio. It's such a pleasure to have with us a retired Supreme Court Justice Paul Anderson of the Minnesota Supreme Court. And we usually bat things around and have a good time, agree, disagree, but always in sort of good faith.
Yeah. Well, it's so much fun to be back in the studio. You know, we've done 2 or 3 virtual interviews, and hey, it's nice having you across the table, you know.
It is. It's really, it feels different. It feels like home again.
Yeah. You know, I've told you to be ruthless in your questioning.
Well, I try, but you somehow or other dissipate the ruthlessness.
You can ask anything you want because I control the answers.
Well, you know, I am an individual who always had the greatest respect for the U.S. Supreme Court. And I see that through the country, that respect has dissipated down to about 10% now. Excuse me. And what's really troublesome to me is I no longer have the respect for the individuals on the court that I once had. I still respect the institution and what it stands for and what it's supposed to do. But I have seen a disintegration of my ideals in terms of the Supreme Court, not the least of which was the latest shadow decision, as they call it, about the Texas abortions, which I think was not only unconstitutional, but unconscionable. And let's start there.
Boy, you have a lot of grist for the mill in that comment. But I'm going to take you one step further, Alan. I mean, yes, we're lacking respect in the individuals, but what they are doing is creating a crisis of confidence in the institution. And so you are not alone in your concern about the individuals, but you should be concerned about the institution, because what's developing is that it can be phrased many ways: the eroding legitimacy of the court, or it's like a cancer of distrust on a institution that is, should be respected, and it has such awesome power. And when people on the court act in complete disregard of the history of that institution and how it works, and you bring up, and if you want an example, it's the shadow docket. And the shadow docket, it's been at the court for a long period of time. It goes back to the time of John Marshall.
Never used like it has been lately, though.
You're absolutely right. It's a procedural management tool that the court handles its rather large, tremendous docket. And if you look at how it was used during, say, the first 15 years of Roberts being Chief Justice, very seldom used, and used in a, to do procedural matters. This latest effort with the case out of Texas, I mean, whatever your position is on abortion and the Texas law, the court needs to follow its rules. And what it did is, in a basically unsigned opinion, with
that was not briefed by both sides. That was not argued by both sides.
Not argued nor briefed, and basically unexplained. And even worse, it was issued late at night, unsigned. I mean, that sounds like a Star Chamber proceeding. That is not who we are as an American people, and is not what we expect of our court. So they are doing things with that institution that are just terrible for what it is. So it's both the individuals and how they are affecting the how the institution is regarded.
And I look back at some of the great justices who have been members of that court, and I am sure that many of them are turning over in their graves. And if we went to the cemeteries, we would see smoke coming up from their grave sites as they're spinning so fast. The John Marshalls of the world and others. Really.
So, I mean, you can even come to a later time, an Earl Warren or a Hugo Black. Now, Earl Warren, for example, Brown versus Education, that's a big opinion. He wrote it as short opinion quite purposely because he wanted it short enough to be published in the newspaper. And but he explained what they were doing. And Hugo Black, was a former U.S. Senator, he wrote short opinions, but you always knew the rationale and the thinking behind what Hugo Black was writing. No explanation at all behind the thinking of the court on this most recent case. And I'm going to point out something else, though. They are inconsistent in how they use the shadow docket. Is that if you
they use it for convenience at the moment.
Oh yeah, but if you take a look at their cases on religion, they use it very differently. In those cases, they are very quick to intervene if they see that they think there's some religious right that they perceive being stepped on. And so it's not only using that docket, but using it in an inconsistent manner. There's a hypocrisy that's involved in that.
And of course, we can go really, I can't escape bringing up Mitch McConnell and the way he has managed to stack the court, not only against all the rules of the Senate, but really of all the rules of good conscience.
Now,
and the last appointment was perhaps even the craziest of them all.
Now, I have it firsthand, talk to people. Amy Coney Barrett has a very high IQ. She's intelligent. But
No.
as I tell young people, is that, native intelligence doesn't equate to being the smartest person in the room or being wise. And she has done some very stupid things that have undermined the legitimacy of the court. 4 justices recently have been out talking about, trust us. If you know us, you'll like us, Well, no. Trust is earned, and it's earned by your actions. And this is what Amy Coney Bryant did. She went to Kentucky to the Mitch McConnell Center, was introduced by Mitch McConnell, and then proceeded to give a speech that said, trust us. If you know us, you like us. That is not how you behave as a justice. I cannot tell you how many times I had to be very careful avoiding any appearance of impropriety. And for her to do that, I mean, it's not very smart.
No, and it is very worrisome. I wrote an article, blogged probably about 5-6 months ago, calling for increasing the size of the court. Now, there's arguments both ways on that, but I think that this court is proving itself to be such that perhaps that's the solution. There are other solutions, term limits and things like that. But you talk about impropriety, and you talk about, for instance, what a judge shouldn't do. I was rather disturbed at a pardon case here in Minnesota not too long ago, where a judge who I thought had an involvement previous, and it happened to be the chief judge of this state, in that particular case.
I'm going to correct you. You know, you like to flip back and forth between judge and justice, but you're talking about the Minnesota Supreme Court. You got to use the term justice.
Justice.
And it was the Chief Justice.
Yes.
So, first of all, I want to back up a little bit about when the Supreme Court behaves in a way that creates an eroding legitimacy with respect to the judiciary. It filters down to all of the other courts. It filters down to the federal courts, it filters down to state courts. And people start to lack, confidence in how the state courts act. Now, the case you're talking about, I'll maybe want to talk about the substance of it, but Minnesota has a pardon board, 3 people on it, the governor, the attorney general, and the Chief Justice.
That in and of itself is somewhat unusual.
It's very unusual. It's a result of legislation that was passed in the 1890s, and it talks about the governor acting in concert with the other 2. And the question is whether it needs to be a unanimous decision or they can be 2 out of 3.
Right.
And the law is vague on that. And the court quite legitimately could conclude either way. But the governor said 2 out of 3. And a person who was denied a pardon because of the unanimous requirement sued. And the Chief Justice took an active part in the litigation. She became a party. She submitted briefs. Now,
and then she sat on the pardon board.
Oh yeah, she sat on the pardon board. Now, I got to be very careful here about how I treat my former colleagues, but I will go so far as to say it surprised me a lot that the remaining 6 justices on the court sat and heard that case where their Chief Justice was a party. And I'm not alone in that. I mean, a number of other former judges and legal scholars were surprised by that.
Well, then she participated in the ultimate decision.
No, she did not. She recused. Decision was made by the other 6.
By the other 6.
But then they made a somewhat like a shadow docket opinion.
Clear conflict of interest on my estimation, however.
Well, the Code of Judicial Responsibility talks about an appearance of impropriety. And I've had to wrestle with that whole concept any number of times. And I always, sometimes to the chagrin of my colleagues, erred on the side, if there's a possibility and appearance of impropriety, I'm out. I would recuse. The thing is, the interesting thing, and I got to be careful, is it's not that hard for the court to get a replacement, not like the U.S. Supreme Court. This case in particular had not gone to the Court of Appeals. So they could have had a panel from the Court of Appeals. Quite easy to have the Chief Judge of the Court of Appeals, and then they could choose the other 6 a couple of different ways. They could take the next 2 panels of 3 that were up in the docket because they have an order, and that could have fleshed out a 7-person court, or they could draw on from the remaining justices drawing lots. So it's not that hard. Now, it wouldn't be the Supreme Court, but you know, it's a way to, and the court has done that. They did that on the Page-Yetka case, you know. When Yetka was on the court and he was part of the thing, they recused themselves, and they had a panel in that case of one Court of Appeals judge and then 6 trial court, district court judges.
No,
so it's not impossible
wasn't familiar
to do.
with that, but
Yeah, no, it's not impossible to do. So let me just end that whole thing about how they handled it by saying I was surprised. But I would like to talk about the substance of the case. Minnesota's pardon system is dysfunctional. And it's dysfunctional because they have to have all 3 unanimous. Now, we've had in the past attorney generals who are governor wannabes. And I'll name names here: Humphrey, Hatch, Lori Swanson. And they're all panicked about this whole Willie Horton syndrome. Remember the 1988 election, Willie Horton, he got out and he killed somebody. They are afraid that if they grant a pardon and somebody does something wrong, that will come up in a race for governor. Now, also, as the way it is now, is concerned, the pardon board is fundamentally about forgiveness. But when you have a member of the pardon board that says we're not about forgiveness, that makes this dysfunctional. Alabama gives more pardons than Minnesota. South Dakota, North Dakota gives more pardons.
in most of those states, it's the governor. The governor might take recommendations from a panel, but it's the governor who makes the ultimate decision. And it's not a 2 out of 3 decision.
No,
it's an individual decision.
You know why they grant pardons or in North Dakota and South Dakota?
No, why?
Grandparents want to go hunting with their grandkids. And they have a criminal offense and they can't carry a gun. And so they come up and say, you know, minor offense done when he was young and whatever, I want to go hunting with my grandson. And
I think that's a tongue-in-cheek remark. But,
no, it happens. It's reality. I mean, you know, hey, there's a lot of pheasant hunting in South Dakota, and no, it's a personal thing, you know.
Now, there's another case that's troublesome, and I know it's a case that you wanted to discuss, and that's the case of Mohamed Noor, who was convicted of third-degree murder and manslaughter.
Second-degree manslaughter.
Right, for the killing of a young woman, and he was in the police force at the time, and she was obviously a dangerous person.
No way.
Standing out in the alley in her nightgown with no weapons, so you can understand why he just pulls out his weapon and shoots her, especially when there was nothing around that would indicate that he was in danger. However, the law is requiring his third-degree murder conviction to be set aside, and that's troublesome to me.
No question that Noor, a Minneapolis police officer who I deemed to be inadequately trained, did something very, very wrong. And that wrong act extinguished the life of a middle-aged woman who was no threat at all. But the question is, did he violate a criminal statute, and what criminal statute did he violate? I think, and now I'm very solid on this, the Supreme Court came down exactly the way it should on the third-degree murder charge. And you know, prosecutors like third-degree murder because they know the facts won't support second-degree murder, but they want a murder charge where they can get a substantial sentence. But third-degree murder is a kind of a quirky, interesting statute. I always had trouble wrestling with it. But it is a statute where a person, you know, acts in a way that's complete, utter disregard of human life. But, you know, somebody acts in a crazy way. I mean, drives a car recklessly down Nicollet Avenue, or you know, randomly shoots. Nobody in mind particular that's the object of their mayhem and murder and mayhem, but people get killed. That's in reckless disregard of life, and the person should have known that acting that way was reckless disregard. But it does not deal with the situation where the act is directed at a particular person. And there's no question in the Mohamed Noor case that his action was directed as to one person. He reached across his partner, pointed his gun, and shot this woman. Bad act, no question. But it was not a random, careless act that was a complete disregard of human life.
So what about second-degree murder?
Well, the jury didn't find second-degree murder. See, that's the problem. Is that, they tried to get second-degree murder, but
there was certainly intent on his part in firing his weapon. There was certainly intent on his part in drawing his weapon. There was certainly intent on his part in aiming at this woman. And as I said, a woman in the middle of the night in a nightgown in an alley, unarmed, I just can't fathom it.
But Alan, our system of justice says you get the right to a jury of 12 people. And the jury didn't agree with you. They tried to make that case. You may disagree with the jury, I may disagree with the jury, but that's the way the system works. The prosecution made its best case on second-degree murder, and the jury said no. And so they did third-degree murder, which is a charge that didn't fit. It's one the prosecutors like, but it didn't fit the case. And so now Noor is, he goes back for resentencing, but it's on the second-degree murder charge.
Later this month, and he's probably going to do 4 years, most of which he's already served.
Yeah, well, this is the thing. Third-degree murder, 12 and a half years, okay? He would serve 2/3 of that and then be on probation. Second-degree manslaughter, and this is where the rub comes with people, they said, it's 4 years. And he's been in prison since 2019, so if he's resentenced, he'll probably be out in less than a half a year. It's hard to get one's head around these things, but I will tell you flat out, the Supreme Court made the correct decision under the law with respect to third-degree murder. And if you got a problem with the statute, go to the legislature, because the court did its job in interpreting the statute as written.
And thus we differ on that one.
Oh yeah, we do. It's tough. It's tough being a justice. You have to make tough decisions, but you got to do it under the law, Alan. And in the law, I had a partner who always used to tell me, Paul, when the case came in, he says, Paul, first thing you do is go to the statute. And if you got problems with this case, I'm going to tell you, go to the statute, Alan, and you'll see that the court did it right.
Well, I never gave up easily.
I know you don't.
And had a reputation for just that. Perhaps that's why they call me the curmudgeon, but...
You're not a curmudgeon. Cantankerous sometimes.
Oh.
All the time.
By design, yes.
By design.
Now, another thing that's really troublesome to me is, and it happened just the other day, one of the January 6th insurrectionists came up before a Trump-appointed judge and was granted a pardon, or not a pardon, but a suspended sentence. And to me, there has been nothing more serious in my lifetime than the attempted insurrection of January 6th and the attempted overthrow of our form of government. I think that judge did a great disservice to justice, to the system, to our form of government, and to that defendant also, in giving him a suspended sentence.
This amazes me also. The ability, now that judge turned a blind eye to what was happening, but the ability of elected officials and to turn a blind eye as to what was happening. More and more information is coming out about this being indeed an insurrection, an attempt to block the result from a very. Hey, I've sat on panels in Minnesota and looked at how elections are handled. We do a good job on elections, so this is a whole made-up deal about, a fraudulent election. But for people to deny that 1,000 people invading the Capitol, they weren't tourists. They were invading Capitol for a purpose. And the interesting thing is that
They wanted to stop the vote. They want from being certified.
yeah. Now there's a report that came out recently, just yesterday, I think, from Congress about some of the background to that insurrection. Okay, interesting thing. Senator Grassley from Iowa wrote a dissenting report and said, "Well, this is not true." He doesn't have any to back up that. But the day before the insurrection, Senator Grassley said that, well, Trump will not be the one who presides and decides. I, as the president pro tempore of the Senate, will be. Makes me wonder what inside information did Grassley have that was going to make him think that he was going to be in a position to preside. I mean, the insurrectionists went after Pence.
Little by little, it's all coming out. It'll take a while, but it is still coming out.
Now, what is
Interesting, Grassley is my age. Well, he's a year older than I am, and clearly both of us are senile and should not be in positions of really
I will not
decision
render an
making.
opinion, but I will render. I mean, you're talking about senility. It doesn't apply here, but senility is associated with a failure of memory. Former Vice President Mike Pence came out with a recent speech, and it seemed like he had complete amnesia about January 6th. They were coming after him. They said that we want to hang Pence, but he now seems to have forgotten that completely.
Well, he seems to have read a different version of what happened on January 6th.
Well, how can he forget the officers, the marshals, surrounding him and escorting him out and trying to get him in a safe place because they felt his life was threatened?
Because it's a situation where he still dreams of being in the Oval Office as the president, and that is a nightmare for perhaps the rest of the country, but it's a dream of his, and as we see with the Congress, they will set anything aside in a false belief.
Are we running out of time?
We are out of time.
Well, I'm going to say one other thing to the public. Keep your eyes on October 26th. President Biden has to make a very important decision on the records of the Kennedy assassination. Watch for what happens, and we'll talk about that later maybe.
Supreme Court Justice retired Paul Anderson, always a pleasure, and we will continue to do this,
It's
I
fun,
hope.
Alan. It's fun to be back in person.